We are going to go ahead and get started. So I just want to say welcome everyone to this week's webinar. This is the fourth class in the Digitization Basics webinar series. It's copyright considerations for digitization. I'm Ms. Gallo. I'm the statewide digitization initiatives coordinator for the Library of Michigan. And I am very pleased to introduce, though she needs no introduction, Claire Mandila, who is the law library consultant for the Library of Michigan. So thank you, Claire, for being with us.
Yay. I'm happy to be here.
So my job is to help libraries and cultural heritage institutions around the state digitize their materials and make them accessible. So in order to do that, we have created this 9-part series that will help lay the foundation for digitizing your collections. And you can see the list of the other classes in the series here, which are held on the last Tuesday of the month. And we'll drop the link for registration in the chat. And I just want to note that you can register for all of the classes or only the ones that are of particular interest, whether you want to learn new skills or if you just need a refresher. And after this series, we'll be conducting some more in-depth classes, both on these topics as well as a variety of other topics. So for example, we'll be doing format-specific classes like digitizing newspaper or scrapbooks and audiovisual material. We'll have some resource-centered classes such as working with vendors or volunteers. And we'll have some procedural classes such as writing digitization grant applications or creating digital exhibits. And if there is anything that you're particularly interested in learning more about, please let me know so I can develop programming around those. And then I also want to say that in addition to the Digitization Basics webinar series, we're also creating a niche academy modules from the material covered in the series so you can hone your skills and earn badges in digitization. And I just want to say that the first one of that should be coming out early this summer. So for now, we're going to go over just a little bit of housekeeping. Somebody asked ahead of time, but I'll repeat it for those of you who are just joining us, that this webinar is being recorded, so you can access the content again later, along with the slides, which will be shared. So this recording will be available with captioning next week, and Becky will email out those slides. I also want to note that if you have missed any of the previous webinars in the series, you can always view them by going to the Library of Michigan's webinar archive. There will be time for Q&A at the end, but you should also feel free to ask questions throughout. You can drop them in the chat and Becky will be monitoring the chat. As we've already seen, Becky is monitoring the chat for technical difficulties. So if you have any issues with the audio or video, please reach out to her so that she can help you resolve those. And last, there are many additional resources on the digitization page of the Library of Michigan's website. And we will drop the link to that in the chat as well in case you want to do any investigation on your own. So today we're going to be covering a variety of topics. We're going to be starting by talking about what copyright is, its impact on digitization, standardized rights statements, and we'll wrap up with risk management. But in an effort to manage our own risk, I would like to put out this disclaimer, and Claire, I'm sure, will agree that the research, resources, and discussions that are part of this presentation are for informational purposes only, and that you should seek legal advice from your lawyer if you have specific questions. So if there's any questions about that, please let us know. All right, as always, I'd like to start off with a poll. So Becky, I don't know if you want to go ahead and launch the poll, but just curious, when do you consider copyright? When you're processing a collection of archival materials, before digitizing that collection, before making collections available online, or what is copyright? Yes, I like the brave souls answering what's copyright. I do. Yes, it's excellent. Great. Okay, so it looks like it's kind of spread across before digitization is taking the lead, which makes sense, especially with the group that we have here. There's no wrong answer to this, and if you ask what's copyright, you are definitely in the right place. So I'm going to close out of this, and I am going to take this opportunity to turn it over to Claire, who's going to start us off.
Okay. Hey, everybody. So my section of this presentation is pretty much just to talk a little bit about what is copyright and kind of more the legal side of it, which I'm sure is not going to come as too much of a surprise for everyone. If you want to go ahead and give me the next slide, please. Okay, so I like to start. I always feel that if you have an idea of where things came from, that can kind of give you kind of a little sense to little kind of some information background that can help you make judgment calls, which in a lot of instances, this area of law is kind of rife with judgment calls. So if you have kind of an idea of the history, it can kind of inform some of those judgments. So this is just a brief kind of overview. So it probably will not surprise you that US copyright law evolved from British copyright law. British copyright law, the first formal copyright law was actually in the 1500s, but it protected the printers and the stationers, because that in the very beginnings, that was what the crown was most interested in, was who could print things. And if you printed it, you owned it. The author didn't own it. So then in 1710, the Statute of Anne, named after Queen Anne, actually kind of moved that ownership into authors and creators. Then in the early days of the United States, as part of our Constitution, the framers pulled a lot of British law into our Constitution. And one of the things that they pulled was the idea of vesting rights of creative and works of authorship into the creators, the people that wrote, the authors, and they actually termed it specifically to say to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that covers also patent law, right? To cover discoveries. So that was the intention behind the constitutional section. And what that section of the Constitution was, is it actually directs Congress to come up with laws, which Congress did in 1789. Along with the first publication of the statutes, they came out with the 1789 Copyright Act, which was designed to put into motion what the instructions in the Constitution say. And the 1789 Copyright Act formed the basis for pretty much what we have today. Vested rights in authors, gave limited terms of ownership. And then came along, 1909 was the first revamping of the Copyright Act after the 1789. There were lots of amendments after 1789, but 1909 really kind of created some big changes. And then in 1976, there was another big change in copyright law, which is the act that we go by today. And in 1976, and again, it's been amended several times since. And one of the things in 1976 was that, again, they extended the length. Now, in 1988, the United States joined the Berne Convention. And this is important. The Berne Convention is an international treaty. And what the Berne Convention did, see, I'm going to backtrack for a minute. European copyright and copyright from other nations can be very different from the United States copyright. The United States has often looked at copyright from kind of more of a corporate view, you might say, whereas the European copyright looks at things from an author's rights perspective. So in the UK, rights vest immediately with the author. So that was very different in the United States. In 1988, when the United States signed the Berne Convention, one of the main things that the Berne Convention did was it removed the requirement to have a copyright notice in order for it to be considered protected by the Copyright Act. Before that, the United States laws required a copyright notice in order to be considered for copyright. So that was a very big change of the Berne Convention. did. Then following the Berne Convention, again, we had some more, amendments, but then we had in, I think in 1998, we had the Sonny Bono Copyright Term Extension Act. Now, some people call this the Mickey Mouse Act too. The Sonny Bono Copyright Terms Extension Act extended the amount of time that your work, owner's work, could be protected. So it is now life plus 70. So life of the author or creator plus 70 years. And, there's big discussion that, a very big supporter of this was, of course, Disney, which, has been close to losing some of the copyright in Mickey Mouse. So that's one of the reasons why it's called the Mickey Mouse Law. So the law pretty much has evolved over the years. But one of the things that hasn't changed is this idea that the purpose of the U.S. looks at copyright as being something that we want to protect the rights of the owner in order to encourage authors and owners to create, but we also want to balance that with the benefit that their work gives the public. Could you go to the next slide? Okay, so let's talk a little bit about what exactly copyright does. So copyright protects the author's rights, and that is to determine how their work is used and also to profit from their work, to get the money. Right now, under that, what we just talked about, life of author plus 70, works created before 1927 are right now considered in the public domain. So if you come across a work you want to digitize and you see that it is copywritten or created before 1927, then 99% of the time you're safe to go ahead and use that work. As I said, it balances the protection of the creators, of the people that create the work, and the benefit of the work for the society as a whole. It limits protections to only certain kinds of works not covered by other laws. And what this means is, for example, you can have works that are trademarked and works that are patented. So the types of works that are trademarked and patented are often different from the kind of works that are copywritten. And then one of the things that the different changes in laws did too is it added different works that were allowed to be copywritten. So one of the laws added music, and one added architecture, and one added dance, and one added sculpture, and one added film. So as technology changes and as arts change, then the laws compensate for this and will add to the copyrightability of these different types of works. Copyright also exempts certain uses. So it also permits the use of some works that to use for public access, as long as that use creates minimal harm to the author. So, and so, sometimes those are also termed defenses, but we're going to talk about that in a little bit. We go ahead and give you the next slide. Thank you. So some things to know about copyright right off the bat is that copyright's always going to vest in the creator of the work. Now, sometimes that gets a little muddy because there are instances where if you work for a company and you create that art for the company, then there may be instances where your work is going to be owned by the company. For example, this has been quite famous in comic book work and in some advertising work where like Spider-Man, when of course his name just went out of my mind. Stan Lee. When Stan Lee created Spider-Man, he was working for Marvel, and so usually, depending on the contract that the different publishing companies had with different artists, that the character they created would be owned by the company and not owned by the artist. And even their sheets of artwork would be owned by the company and not the artist. And so a lot of times these artists were actually really kind of, I guess you could say, unfairly treated. They weren't really allowed to really profit from their work. So there are different kind of circumstances within copyright law which can dilute the value of the work for the creator. But generally, if you create something, especially right now under the law, then you're going to own that work. Just because you own a copy of the work does not mean you own the copyright. And this is important because and this is actually something that people get confused about when you don't know a lot about copyright, or if you have, say, a set of newspapers, or you have a set of photographs, and you want to digitize those. The fact that you own that particular photograph doesn't mean that you own the copyright, right? Just because you own it doesn't necessarily mean that you have a right to digitize it or do whatever you want with it. There is something called the first sale doctrine in copyright. And what that means is that usually that's talked about in terms of like written works. So if you have, but it can be applied to photographs, if you have a copy of a work and you want to sell that copy. So for example, I own a copy of the Harry Potter, first edition Harry Potter, and I want to sell that. So I can put that on eBay and sell that copy of Harry Potter. And that is not a copyright infringement because I'm selling the actual tangible object that I own. I'm not selling, any right to reproduce that copy. I'm just selling that actual item. So you have to be careful not to confuse like first sale doctrine with the actual ownership of the copyright of the item. There are exemptions in things like we're going to talk about section 108 that permits libraries to make photocopies of things or permits people to make copies of things. You have like things like the Sony Betamax case, which was a very big fair use case that permitted people to make, record videos on TV, record your TV shows. So there are instances where, you can copy something, but generally, just because you own the actual item itself doesn't automatically give you a right to copy that or to create a new work out of that. It just means that you own the item and you can dispose of that item. Whether a work is on, when you're trying to decide whether or not something is under copyright, you have to understand that can depend on a whole myriad of factors. It can depend on when the item was created, the year it was created. It can depend on what the item is. So you don't ever want to assume, right? Sometimes the easiest one, so, okay, it's earlier than 1927. I know it's public domain. It's a US government document. I know it's public domain. But there's going to be other items where it might be a lot more unclear. And so the rule of thumb here is that if you're not sure about the copyright, you always want to verify. Never just go with your gut, because that can end up getting you in a lot of trouble. Things like sound recordings, movies, things that are already digitized. So electronic databases, books that are on electronic databases, all of these can be treated differently than things in text. So you have to be really careful because copyright is very much a if then that kind of situation. It's not nice and linear always. You could have one work that might actually be dealing with multiple copyrights. So if you have for example, if you have a Harry Potter and you have the copyright for the story, for the text by J.K. Rowling, but then you also have in those early editions, you have some beautiful illustrations, and those illustrations are owned by the person that drew them. So you could possibly have rights in each of those that you have to deal with if you're going to just take a copy of that and scan it online. So, you have to look at illustrations and photographs versus text of items also. So those are other things to be careful of. Details matter. Okay, so if you have something from, a really good example is, as I said, a lot of Disney stuff is starting to become, or things we associate with Disney are starting to become in the public domain. So one of the things that came in public domain this year was Winnie the Pooh. But something to remember is that what came into the public domain is the original story of Winnie the Pooh by L.L. Milne. So that book, that original book came into the public domain. Disney's Winnie the Pooh did not come into the public domain. So even though the story is in the public domain, that depiction and those illustrations are not in the public domain. So those kind of details matter, right? So you have to, be really understand the item that you're looking at, what it is you want to use, and what the details for that item are, including things like date and format. Photo, music, art can all have different requirements, sculpture. So you have to, music especially is really, really, music is one of those things, I want to say it's like really, I want to say scary, but it's the reason why I want to say that is because the music rights owners and the groups that represent them are very, very hyper aware of their rights and when they're being infringed. And they employ an awful lot of digital and technological resources to ensure that their rights are protected, which is not a bad thing, but it can be scary for people that misuse it. So you want to be really careful about everything from putting music on a podcast or a digital program that you're doing for your library, to including music on a digital project that you're doing, to digitizing sheets of music. So, music is almost a world of its own. So you want to be really, really careful and double check and triple check before you start using music. And the same can be true of, performance, like film. Photos, the person who took the picture is always the owner of the photo, unless like a text, a corporation or something is involved that may own that document. Even unpublished works can be published. Can be protected. The Copyright Act has a section on orphan works, works where you're not sure who the author is, works that you're not sure if they're published. So this could be diaries. If you have diaries from ancestors or diaries that are donated that you want to digitize, you don't want to assume that you can do whatever you want with them just because they don't look like they're published. So you want to also look at the requirements for that kind of copyright, because the law does protect unpublished materials. And as I said, just because if you have a work that is not protected by copyright, depending on what it is, if it's an image particularly, or if it's like a slogan, then it is possible it could be protected by trademark, or if it's patents are just processes. So odds are it's probably not going to be a patent, but it could possibly be a trademark. Will you go to the next slide? Okay, so now we're going to cover a little bit of fair use. Yes, thank you. So fair use, which you probably are very familiar with that term, that first appeared in that 1976 Copyright Act. And that actually was originally what we call a common law. And actually all of copyright law started out as quote unquote common law. And what we mean by common law was the law developed through case law. So it wasn't written down in a statute to begin with. It was written, this is, long time ago, British. It was just, kind of nobody knew. And then one person sued somebody for using their stuff, and the law started to develop in case law. Then once there were enough cases, it started to be actually recorded as a statute. And that's kind of what happened with fair use. Once we had copyright law and ownership was vested in an entity, whether it was, under statute of Anne, whether it was publishers, or later on, whether it was authors, then we had, people saying, well, hey, I was only using a line of this in my advertising, or I was only using, this statement to illustrate something else, or I was only drawing a picture of your story. And, people were suing. So the courts were saying, well, this is what we think is fair. This is really not copying your use. And on the other hand, this might be a problem. So the fair use doctrine kind of evolved out of that case law. And so in 1976, Congress went ahead and put it in the act. Now, it's considered a defense. And what we mean by that in like legal parlance is whenever you have a statute that can be violated, that people can violate, one of the things that happens is when you go to court and you're told, okay, we're accusing you of violating, this statute, most big statutes like the Environmental Protection Act and Civil Rights Act, and they will have built into the law certain defenses. And these are, kind of like exceptions, or these are things that if you are called on the carpet and you are, accused of violating it, or in this instant infringement, you can say, no, my use falls under this defense, this safe harbor, this exception to, prosecution. So in other words, it was okay, I did do it, but it was okay, I did it, and this is why. So one of the things to know about fair use is we're going to go through the 4 elements of the fair use test, which also was created through a case. But one of the things to know is that you can run through those steps as many times as you want, but in the end, something is not officially fair use unless a court says it is, because this is meant to be a defense. So just like I talk about with obscenity, it's up to the courts to decide really what's obscene or what is fair use. And the test is there, and we go through the test because it can give you a guide. It can give you an idea of if what you're doing, again, we're talking judgment calls, and in a little while, Biz is going to talk about risk. So just like many law, it's about, hedging and looking at your risk benefit calculation. So I really think that all of my reasons for using this are weighing down on the side of it being fair use, but I can't absolutely definitely say it is going to be fair use unless someone sues me and the court says it's fair use. The purpose behind fair use was to allow copywritten material to be used for purposes that benefit the public, things like education, things like entertainment, like parody or critique or news. So the purpose of it was to benefit the public, but at the same time, not unduly harm the author and take huge amounts of money or profit away from them. So right here, these are kind of the key things about fair use. Parody, so, think Saturday Night Live. Critique, like people who critique movies and show clips. Research and scholarship, so all of those articles that are written where people cite to works or quote works. Or to create an entirely new work. And one of the most recent versions of that would be something like when, musical artists sample earlier works of music, right? They might take a few bars or a few seconds of a well-known song and use it as at the beginning or in the bridge of their current song. So, you can take a previous work and use part of it to create a whole new work that is something that the author, may not have contemplated. Fair use, one of the most famous fair use cases is the Sony Betamax case, which was the case that decided that, you can record TV shows for watching later. Because they considered it's called time shifting. You're not copying the show to profit from it. You're not copying the show to, take something away from the owners of the show. What you're doing is you're copying the show so that you can watch the show later, and you would have watched the show anyway. And so that kind of fair use case is one of the cases that a lot of Americans kind of connect to fair use. Okay, going to go to the next one. Okay, so this is the fair use test. It's four prongs, they say. So the first is purpose and character of the use. How do you want to use this? You're using it exploitative to the original author? Are you trying to get around from paying the author for use or getting permission? Are you using the work in a transformative way? Are you taking the work and creating something new with it? What is the nature of the copyrighted work? Is the used material, is that original work you want to use, is it a work of fiction? Is it a newspaper? You know, how does that work? How does using that work, go along with the constitutional goal of encouraging the useful arts? Is it something that is encouraging the use of the work in a whole new way? Amount and substantiality. Are you using the entire work? You know, so if you're using a photograph, then that's going to pretty much use the entire work, right? But, you know, because obviously taking up just a portion of a photograph in most instances is not going to be very useful. Are you using just a chapter of the book? If you're using just a chapter of the book, how big is the book to begin with? In academia, for ILL purposes, we would use something called the CON2 guidelines, which would say, okay, you could take, 1/10 of the work. So loosely one chapter out of a multi-chapter work. But if the work only has 2 chapters and you're taking 1 chapter, well, that's a kind of a different story. And then effective the use. Are you pretty much taking this use? Is it taking money out of the hands of the author? Is your use of this item instead of purchasing and buying one? So are you using the purpose of your using this work only to not have to pay for a new one? And that, I would used to tell students, well, if you're using this work is costing the owner of the work $1, then most likely it's not going to be fair use. So, and these individual prongs can in and of themselves be very kind of sticky, right, in their analysis. So there are whole, books written on each individual one of these. So that's one of the reasons why, it's up to courts to decide if something is fair use. So, under purpose and character is also where you'd put educational, is your use educational? And that is something that, again, is a word that's bandied about a lot in copyright, educational fair use. And the thing is that there isn't really something called educational fair use. It's just that an educational use is a component of the 4-part fair use test. Will you go ahead and thanks. So the thing about educational fair use is that it's very easy for libraries as places that educate people and that provide educational resources. It's very easy to consider that any use that a library wants to use, because they're nonprofit, because they're public, would mean that it would be fair use. And the problem is, that's not the case, because when the copyright law looks at educational fair use, what they mean by education is an educational institution. So they're thinking specifically of schools and colleges and universities. And so that's very important to consider. When they're looking at education in this context, they're not thinking of things like public libraries. They're thinking of schools. And schools and are treated differently very often under copyright law. There's a lot of leeway given to schools for purposes, especially of in-classroom teaching and digital teaching, that are not afforded public libraries. Public libraries under the law are not considered to be educational institutions. It's a really narrow definition. And then even if your use is educational, you still have to go through those other prongs of the fair use, the other 3 prongs of the fair use test. It being educational alone is not going to be enough for you to say, okay, I don't have to worry about copyright because, hey, it's an educational use. It's for public libraries. It's so that people can know their past. It's a good thing. That doesn't matter. You have to really walk through the whole analysis. And again, even though courts tend to give a lot of weight to non-commercial educational use, especially that non-commercial part is probably more important than the educational part. The determinations and the decision-making on copyright is still a very individual thing, right? Courts will even look at, okay, because universities have failed on this. If you're a university that has a lot of money, if you're Harvard and you try to plead educational fair use for using the entire text of something, then courts may look at that and say, look, you could afford to pay for this and it would be no big deal, so we're not going to give you that, nonprofit educational fair use hook. We're not going to let you have that because we know that you are very wealthy and you could pay for it. But on the other hand, you have a very small school district that is not very well funded, and the courts may say, yeah, okay, that's okay. So, the courts also weigh this idea of, benefit to the author versus, the benefit to the public. And because copyright is meant to encourage the useful arts and encourage creativity, the courts want to make sure that those authors are rewarded. So pretty much it's not a slam dunk. You always have to do your homework is kind of what we're saying by this. Okay, okay, now we're going to talk about Section 108. So Section 108 of copyright law is what's called the library exemption. And it's kind of, Section 108 has always been like the library section of the copyright law. And libraries do have very special privileges with respect to copyright. And in some instances, they're even better than what, schools have. The reason, purposes of, or rather the reasons why people can go in and make a photocopy of things. And the reason why, you can have a copying machine in a library with all of those books and have it be unattended and just, let people do their own thing is because of Section 108. Section 108 puts that responsibility on the user of the copier instead of the library. Section 108 gives, permission for copies to be made of, a fair amount of the item for purposes of research and preservation. Now, when we talk about preservation, and this would also be a digital copy, we're talking about things like you have something that's very fragile. You have an item that needs to be, preserved because the actual physical item is falling apart or can no longer be read or can no longer be handled, or the item can no longer be purchased. You can no longer find it, or if you do find it, it's some obscene amount of money. It's not a reasonable cost. So if you're in that kind of situation, then that's what this exemption is meant to do for libraries. It's meant to permit the library to, take parts of its collection that are, no longer practical to have out on the shelf and be used, and reproduce them so that they can continue to be looked at. One of the kind of contingencies of this is that the material has to be viewed within the library. So, if you're going to plead Section 108, then it's going to say, well, okay, it's okay to take all this material and, copy it because it's preserved, but then, you can only view that material within the library. So that means including digital copies. So if you're going to, digitize, a whole stack of very brittle newspapers, then this section of the law would say you can digitize it, but you can only view it from inside the library. This section is also the section that permits interlibrary loan. Permits the copying of chunks of material and sharing it, which very often the reason why you share is because the other party doesn't have it. And you would think that's precisely what the Copyright Act doesn't want. Well, this was carved out specifically for libraries because libraries do a lot of that, right? Libraries do a lot of sharing materials back and forth. And so again, it was okay to send material, copies of materials, like I said, a chapter of a book or, information back and forth. But again, there were certain limits. Reasonable limits placed on this material. If you're sending full text of books copied back and forth, that would be a copyright issue. Would you go to the next one? Okay, now I'm going to shift it over to Biz, and I will take a look at the chat.
All right, so I'm going to be looking at standardized rights statements. So in cultural heritage institutions, we're often not the intellectual rights holder of the content in our collections. But what we do hold is a responsibility to understand and convey if and how those collections can be used. Best practices asks that we provide rights information about digital items, and various metadata schemas stipulate where that information goes, but provide little guidance on how exactly to represent that information. So everyone conveys or used to convey this information in different ways, using different language, leaving room for questions, ambiguity, and even legal liability. On the screen are a few examples of various rights statements found in digital collections. And I can say that I don't feel confident about the right status or potential use of materials that these describe. This is one of the reasons that rightstatement.org was created. So rightstatement.org, which is a joint effort between the Digital Public Library of America and Europeana, created a controlled vocabulary for describing high-level copyright statuses so that institutions from all over the world could describe right status in a uniform way. They developed 12 standardized statements to indicate the right status of digital collections, specifically to meet the needs of cultural heritage institutions making digital collections available online. The 12 statements cover all possible statuses between the United States and Europe and are organized into 3 categories. There are categories for works that are in copyright, works that are not in copyright, and for works where the copyright status is unclear. These statements provide end users with easy to understand, high-level information about the copyright and reuse status of digital objects. And we're going to take a look at a handful of them in closer detail. So we're going to start with the in copyright category. And there are 5 statements that apply to digital objects that are, you guessed it, under copyright. So in copyright would apply to items that are covered by copyright, and the organization making them is either the rights holder, has obtained permission from the rights holder, or is making it available under an exemption, such as fair use. The next is for EU orphan works, which would apply here in the US. The next are educational use permitted and non-commercial use permitted. Both of these statements specify uses, have specified uses that are allowed by the rights holder without obtaining advance permission. Last is rights holder unlocatable or unidentifiable. For this, you would have determined that the item is in copyright, but the rights holder has not been able to be identified or located after a reasonable investigation. As cultural heritage organizations in the United States, we're most often going to use either in copyright or rights holder unlocatable or unidentifiable. Next is the no copyright category. There are 4 statements for works that are not in copyright. The first 3 statements listed apply to items that are in the public domain, but have some restrictions about their use, and these mainly apply in Europe. The last statement is for works with no copyright restrictions in the United States. No copyright United States is the statement you'll be most likely to use and describes items that are free of copyright restrictions in the United States and can be used freely. This is what we equate with items in the public domain, though they may still have copyright protections in other countries. Last is the other category. There are 3 right statements for items where the right status has not been determined with certainty. These should only be used if it's not possible to assign a clear right statement. First is copyright not evaluated. This is where the copyright status is unknown and the organization has not taken the time or effort to determine its status. Next is the copyright undetermined. This is when copyright status is unknown, but the organization has undertaken an unsuccessful effort to determine the copyright status of the work. This is likely because there are key elements missing that are necessary to determine the status, such as the date of creation or publication. Last is no known copyright. This is when the copyright status is not known conclusively, but the organization has reasonable cause to believe that it is not covered under copyright. If you're providing online access to material and the right status is not known definitively, you should be using either copyright undetermined or no known copyright. Copyright not evaluated indicates that your organization considered copyright, but made no effort to determine the right status of the material, which could be problematic if the material is under copyright. You may very well discover that you just don't have enough information to determine an item's right status, but you should still be making a good faith effort to assess copyright status and convey the appropriate information to potential users. If you are making your collections available online, and especially if you're contributing to the Digital Public Library of America, it's highly recommended that you include a standardized rights statement in your metadata. But how do you know which statement to apply to an item? Luckily, there are two very handy tools available to identify the appropriate standardized rights statement. The first is Rights Review, an approach to applying rights statements from rightstatements.org by the Minnesota Digital Library and University of Minnesota Libraries. This decision tree-like tool guides users through a series of yes or no questions to help identify the copyright status and corresponding standardized rights statement to apply. This is a great tool and is updated January 1st of every year as new material enters the public domain. The other tool is the Rights Statement Selection tool by Gabriel Galson of PA Digital. This interactive infographic provides multiple entry points for arriving at your correct rights statement destination. It also includes hyperlinks to useful tools related to copyright, such as copyright status determination tools and Creative Commons licensing charts. Intended to be used by novices, it enables cultural heritage institutions to assign rights statement review work to non-experts. As more and more material is being made available online, organizations are taking the opportunity to update their metadata in many ways, including applying standardized rights statements based on existing rights and use information. I would like to note that this tool is not updated annually like the Rights Review tool, and it is focused more on the statement selection and relies on the rights assessment being done as a separate process. I did have some activities, but I'm going to skip over those so that there is time at the end for questions, because I'm sure that there will be a lot of questions. So these will be included in the slides, so you can always go back and review them later. All right, I'm going to move on to risk management. As we said, there will always be some risk associated with digitization. In his book, Copyright and Cultural Institutions, Peter Hurdle discusses some of the risk factors associated with digitization of cultural heritage material. First, the copyright status of the work may be unclear. There will always be material in our collections that we just don't have enough information to know for certain what its copyright status is. Next, it may not be possible to identify all of the copyrights in a single work. Think of a complex copyright object like a scrapbook, where there are many items that are taken out of their original context and combined into something new. Even if you know much of the information about an item, you may still be unable to identify or locate the copyright holder. If you can't identify or locate the copyright holder, you can't request and secure permission to digitize the material and make it available. Alternatively, even if the work is in the public domain in the United States, it may still be protected by copyright in other countries. Finally, individuals and groups may believe that they have more rights to material than the law allows. They may try to either stop material from being digitized or to gain from it. Even if the law is not on their side, you'll still have to invest time in addressing these claims, whether to hire legal counsel or even going to court. So with all of these risk factors, it begs the question, should cultural heritage organizations shy away from digitizing altogether? Hurdle and I would both say no. There will always be some level of risk involved, but it's up to you to determine what level of risk you're comfortable with. This will likely be determined both at the organizational level and at the project level. And every organization will have to determine that for itself based on its own resources. For example, a large university with extensive legal and copyright resources at its disposal may be more inclined to take risks than a small historical society with limited access to resources. As part of your copyright discovery process, you'll need to undertake a reasonable search before you can make a determination. But what is reasonable? It's not enough to look at an item, see that it's not stamped with a copyright symbol in a year and say it's copyright undetermined. That also doesn't mean you should spend hundreds of dollars on staff time investigating the copyright status of a single item that, even if it is under copyright, would have a minimal licensing fee. So here are some places to start if you're looking to conduct a reasonable copyright search. You can check the name, date, or existing copyright information on the object itself. Things like newspapers or published material should have this. If it doesn't, you can check the provenance information. Maybe the object itself doesn't have information on it, but it's part of a collection where there's a lot of information known about its creation that can inform the copyright status for the entire collection of materials. You can search the object and catalog records. Maybe somebody has already done this for you and that information is just being kept elsewhere. You can check with staff. Maybe someone remembers who donated the collection and you can follow up with that person. You can also reach out to your local community. Crowdsourcing metadata and discovery has become increasingly popular, and it's a great way to engage your community about its history. You can take it a step further and advertise in trade journals, because we all know that there are dedicated interest groups out there that have a wealth of information, and they're usually willing or more than willing to share their knowledge. You can do an internet search, which does cast a wide net and can lead you down rabbit holes, but you can still be successful. And finally, ask other collections. They might be able to share information that they were able to gather about similar material. If you are going to have materials available publicly in digital form, I always recommend that you include a takedown policy statement on your site or hosting platform. That way, if there is a copyright claim, they know how to address it and that you are being considered a good actor if there's ever legislation or a litigation. Hopefully, the first time you hear from a copyright holder wouldn't be in the form of a lawsuit, but rather as a takedown request. Here is what to include in your takedown statement on your site. Make sure to get the contact information from the requester. A name and an email address is a minimum, but the connection to the material should be included as well, as these requests should only be coming from the copyright holder or an agent working on behalf of the copyright holder. I can't just say that this is under copyright and I want it taken down if I have no legal right to the work. Next, be sure to get a specific identifier for the work in question. This may be an accession number or the URL for the digital asset. Next, provide instructions for how and to whom to submit the request. If there's an email address or a form to fill out, provide clear instructions so that they can submit the request. Last, provide a timeline for the response so they can manage their expectations. This may be that they will get a response within 24 or 48 hours. This does not mean that you will take down the content either immediately or permanently. It just means that you will review the request within a stated time frame. Which leads me to the final part of having a posted takedown policy. Be sure to have a documented internal policy for handling takedown requests. Who handles them? What's your time frame for response? Do you take the item in question offline immediately until there's a determination made? Do you leave it up until there's a determination made? Whatever it is, document it and follow your policies if and when a request comes in. Copyright considerations for digitization should be a series of decisions. If you're planning to digitize material, you can follow Hurdle's safe digitization workflow, which will take you through a series of questions to decide when you may digitize. Now, the term safe is a bit misleading here, so I put it in quotes, as very few of these are entirely safe. Each step in the process increases its associated risk, but by progressing through the workflow, you can minimize the possibility of violating copyright law. So Hurdle says you may digitize when you are the copyright owner, such as if you are personally created the work or your organization is the publisher and you still own the rights. If not, you may digitize the work if it is in the public domain. That means that you have sufficient information to determine that the work is no longer protected by copyright in the United States. If not, a Section 108 exemption applies. Claire talked about this. And if not, maybe a Section 107, which is fair use exemption applies. If not, you have secured permission from the copyright owner. This can be a little bit tricky as it's not always clear who the copyright holder is. Somebody may believe that they are the copyright owner, even if they are not, or they have already transferred the rights to somebody else. If permission can't be secured because the copyright owner can't be located, then you should reassess the fair use analysis. At this point, you've reviewed the content, attempted to identify and or contact the rights holder, and determined that you will take the risk to digitize the content. But when you do, remember to explain, solicit, document, and avoid commercial use. Let's look a little bit closer at these ways to mitigate risk. There are certain steps you should take to mitigate the risks related to copyright infringement on digitized material. Hurdle recommends 4 key elements to help mitigate risk. First, you should explain what you're doing. If you're providing access to material that you think is in the public domain, say so. If the material you're providing access to is under copyright, but that you're providing access under a fair use or preservation exemption, say so. Be clear about your intentions and state that information on your website or hosting platform. A great way to do this is through using standardized rights statements. Next, solicit information from copyright owners. By having a statement on your site requesting information about collections, you can start a dialogue with your organization and the copyright owner. The Library of Michigan has a section on its LM Digital site, which hosts our digital collections, stating, if you're the copyright owner or have information about the copyright status of an item you've seen on our website and believe that we have not properly attributed your work to you or have used it without your permission, we want to hear from you. Please contact us using this form, there's a link to that, to notify us. This is a great way to invite potential copyright owners to assert their rights and at the same time create certainty about something before where there was only ambiguity. Whatever your project, be sure to document your copyright investigations. If you're making something available under fair use, there are several tools you can use to make that assessment, and these decisions should be documented and kept with the file. If you have permission from the rights owner, be sure that permission is in writing and stays with the content for future reference. Whatever your data or analysis is, be sure to document it. Last, unless you're the copyright holder, have secured permission to digitize and commercialize on the work, or the work is in the public domain, you should avoid commercial use of any digitized material. It will not reflect well on your organization if it goes to court. It negates Section 108 exemptions, and it is a mark against the fair use exemption. Digitization can be a great way to make revenue by selling or licensing content, but you can easily lose that revenue and more if you don't have the rights. Now, taking these 4 actions may lower the risk of legal ramifications associated with digitization, but they're not a guarantee of anything. Past precedents has shown, however, that taking these steps would suggest that you are a good actor and are trying to act responsibly in relation to copyright. Remember, there is no digitization without risk. It is up to you to determine what level of risk you will accept and take steps to mitigate that risk. In the end, it is important that we as collection stewards respect the rights of copyright owners and take care not to infringe on copyright protections. But to that end, as stewards of historic collections, it is also our responsibility to preserve and provide access to the collections in our care. It is up to each of us to thoughtfully balance the risk with the benefits of fulfilling that role. All right, so that's it for today. We do have a little bit of time for questions. Key takeaways: digitization is risk. If you're not sure, err on the side of copyright protection. Document your discovery, use standardized rights statements if available, have a takedown policy, and explain, solicit, document, and avoid commercial use. So I'm going to skip to...
Can I say one thing, Biz?
No, you may not. Yes.
Okay.
What do you have?
We've talked about takedown policies in terms of when you get a takedown letter from a rights holder, like a studio or a owner of an image for your website, or sometimes you get letters written from someone who is caught someone on using the internet to pirate materials. That this is kind of a little bit different than that. So if you get a takedown, letter for an image that's on your website or on your social media site, that you may want to have a slightly different policy for that than you have for your digitizing projects, because especially if that rights holder is what often happens is they'll say, okay, we took a picture of your website on this day and you got, we're charging you $2,000 for the license to this image that you have. And they have a picture of you actually having the image that you did not get a license for. You don't want to leave that image up while you're trying to figure out, whether or not you did cause a problem. You want to take it down right away so that you don't get higher fees for leaving it up while you're trying to figure it out. So I think there are some instances where You know, you may want to have one policy for your digitization and one policy for like your social media or other circumstances, but you could talk to your lawyer about that and they'll advise
Always
you.
talk to your lawyer about it. And I do have at the end, there are a few slides that have resources on various topics, and there are examples of takedown policies that you can look at and develop your own in conjunction with your lawyer. All right, so I see that there have been many questions in the chat. I don't know if people want to unmute themselves and ask questions, or if Claire's been answering them as we've gone.
I've been trying to answer them in
Okay.
the chat.
Okay, so I'm just going to start at the bottom because that's where I am. So Leslie says, unfortunately, we had an experience in which someone maintains they have copyright to some content in our collection, and we don't believe this is accurate, but because of the risk of litigation, we have deferred to him. I guess I would say, what is your reason for not believing him? What work have you done on your own to determine who the rights holder actually is, or if it's in the public domain? And then alternatively, what is he presenting to the contrary?
This relates to magazine publication in which the ownership of the magazine changed a number of times, and the actual ownership trail has been lost. And we did research it and came up with a dead end. And everyone we spoke to who is familiar with the magazine and its original publisher basically said that they could not help us figure out what happened. And it's the son of the publisher who insists that he owns the copyright. The main implication of this is just that we just feel that his insistence on, owning all rights to the content, it creates some pressure on us, although we use the fair use to make that content available. It does mean that we don't feel comfortable pursuing any other kind of public use. So I think it makes it possible for researchers to find us and find the content, but it restricts the public access, I think, unfairly, but we don't have the resources to pursue this any further. But I guess I just want to share, this is one of those things in which the person who insists they own the copyright, even if that's not true, who wants to take this into the courts to try to solve it? It's not worth it to our institution to do that, so we're kind of stuck with this. And that's just kind of our story.
Yeah. And you've done your risk assessment, whether it's not worth the risk to your organization to continue to make this material available. So it's an unfortunate occurrence, and I wish that it wasn't. Is it the son of the original publisher or the new publisher?
Good question. It's the son of the original publisher, but then the publication was sold and then resold. And as far as we know, there were like 2 or 3 turnovers. Different partners bought and sold shares, and it moved from Michigan to California and Florida. Just a bunch of things that it's like too messy for us to keep pursuing.
Well, I would say we can look at it a little more closely, maybe together. We can follow up with you if you'd like. Let's see.
Thank you.
Yeah, of course. It looks like Claire answered Jeffrey's question about an undated photograph. We're a little bit over time, so we can answer questions. We can stay on to answer questions. Do people have more questions? Because it looks like Claire's been answering them.
There's one here I didn't answer, which would section 108 and viewing digitized material only in the library. What if the digitized material is accessible on the library's webpage? Is that still in the library? I would actually have to research this, but my sense is no, that they would not count material digitized and available on the open web as in the library.
It might be something where if you have it restricted to, IP addresses on campus or something
Yes.
similar, depending on the type of library.
Or you have to use your card number to log in,
Mhm.
your library card number, then right, absolutely.
Yeah. Okay. Well, we can stay on afterwards to answer some questions. I'm just going to wrap up a little bit. So thank you very much for joining us today. The next class in the series is Funding Your Digitization Project, which will be on May 31st. Becky's going to drop the link for that in the chat. I also want to thank IMLS for making this project possible. And again, just another plug for the Library of Michigan's Access to Information Grant, which is now open through May 31st. So if you're interested in applying to get some funding for digitization, you can visit michigan.gov/LSTA, or you can contact me or Karen Reich. And then also digitization kits are available and they are circulating. So you can see all the information for that on the Library of Michigan's website under the digitization kit section. And then also just like to drop the survey for the presentation in the chat so that you can help us improve our programming. But as always, this is my information and Claire's information. You can contact us with questions about any of these topics, and we look forward to hearing from you soon.